The story does not begin with a crime. It begins with an anomaly. By the late 1990s, a private individual with no visible corporation, no publicly traded company, and no inherited industrial empire controlled an infrastructure usually reserved for heads of state and multinational executives, multiple aircraft capable of international travel, estates on 2 continents, a privately owned Caribbean island, and a network of staff, pilots, security personnel, and legal intermediaries operating across borders. All of it was legal on paper. All of it existed in plain sight. Flight logs show repeated international travel on privately owned jets. Property records confirm ownership of mansions in Manhattan, Florida, New Mexico, Paris, and the U.S. Virgin Islands. Corporate filings trace shell companies and trusts registered in multiple jurisdictions. Employment contracts required confidentiality agreements that extended beyond termination. None of this violated the law. None of it required secrecy, only discretion. This was not the world of a recluse. It was the world of access. The aircraft were not charters. They were owned. The island was not leased. It was purchased outright. The residences were not symbolic. They were operational. For years, this private world functioned alongside global finance, elite philanthropy, and political society without meaningful scrutiny. It intersected with universities, foundations, banks, law firms, and government agencies. It relied on the same systems that move capital, influence, and people across borders every day. Only much later would that world become publicly visible, and only after it began to fail. This documentary is not about rumor or speculation. It is about infrastructure, how a privately controlled network of aircraft, properties, legal entities, and personnel was assembled, how it was protected by ordinary institutional processes, and how its existence reveals a broader truth about modern power. To understand how Jeffrey Epstein's private world came to exist, the story must begin before his name entered the public record, inside the financial, legal, and social systems that made such a world possible. Context: the systems that came first. Long before Jeffrey Epstein became a public figure, the architecture that would sustain his private world was already firmly in place. In the final decades of the 20th century, wealth began to behave differently. Capital no longer remained anchored to factories, shipping routes, or national balance sheets. It became mobile, digitized, deregulated, and increasingly abstracted from place. Financial markets expanded in scale and speed. New instruments emerged to move money across borders with minimal friction. Jurisdictions competed to offer discretion rather than transparency. This shift did not happen in secrecy. It unfolded through legislation, regulatory reform, and international agreement. In the United States, the deregulation of financial services in the 1980s accelerated the growth of private investment vehicles, hedge funds, and bespoke wealth management. High net worth individuals no longer needed public companies or industrial empires to command influence. Wealth could be managed privately, structured through partnerships and trusts designed to minimize disclosure. At the same time, offshore finance matured into a parallel system. The Caribbean, Switzerland, Luxembourg, and later Singapore and the Channel Islands developed legal regimes that allowed assets to be held through shell companies whose beneficial owners were shielded by law. These structures were not inherently illicit. They were marketed as tools for tax efficiency, estate planning, and risk management. Law firms and banks built entire divisions around them. By the 1990s, it was possible for an individual to control substantial resources without leaving a clear public footprint. Ownership could be layered through entities registered in different jurisdictions. Decision-making authority could be separated from nominal ownership. Financial activity could be routed through private banks, whose client lists were protected by confidentiality statutes. This environment rewarded those who understood process over publicity. Elite wealth management increasingly emphasized insulation. Private banks offered concierge-style services that extended beyond finance into travel, security, and staffing. Legal advisors coordinated asset protection across borders. Accountants ensured compliance while limiting exposure. The goal was not invisibility, but controlled visibility, appearing only where necessary and only on favorable terms. Parallel to these financial developments, another system was transforming: aviation. The deregulation of U.S. airlines in 1978 did more than reshape commercial travel. It accelerated the growth of private aviation. By the 1980s and 1990s, owning or leasing private aircraft had become a practical option for individuals whose time, security, or privacy justified the expense. Fractional ownership models emerged. Corporate flight departments expanded. Airports built fixed base operators, private terminals that bypassed main concourses entirely. Internationally, private aircraft benefited from simplified customs procedures and reciprocal agreements. Passengers could clear immigration without entering public terminals. Flight plans were not posted, manifests were restricted. The system prioritized efficiency and discretion, not oversight. Private aviation did not exist outside regulation. It existed within it, structured to accommodate those who could afford it. At the same time, property ownership followed a similar trajectory. Real estate in global cities became less about residence and more about positioning. Townhouses, penthouses, and estates functioned as assets, social signals, and operational bases. In resort regions and offshore territories, private islands and gated compounds offered something more: specific, controlled environments. Jurisdictions such as the U.S. Virgin Islands encouraged private development through tax incentives and flexible zoning. Large tracts of land could be privately owned. Construction could proceed with limited public scrutiny. Local economies, dependent on investment, rarely challenged wealthy landowners whose projects promised employment and revenue. These properties were not designed to be hidden. They were designed to be insulated. Staffing completed the system. Domestic employees, pilots, drivers, and security personnel were hired through agencies that specialized in discretion. Employment contracts routinely included non-disclosure agreements. Staff turnover was managed compartmentally. Few employees had visibility into the whole operation. This was standard practice in elite households and corporate environments alike. By the end of the 1990s, the components of a private world were readily available to anyone with sufficient resources and the right advisors. Financial opacity could be achieved legally. International movement could be streamlined. Properties could be acquired in jurisdictions favorable to privacy. Labor could be organized to minimize internal transparency. None of these systems were designed for abuse. They were designed for efficiency, protection, and autonomy. But together they created conditions in which extraordinary control could be exercised without external scrutiny. It was within this landscape, not outside it, that Jeffrey Epstein would build his world. How elite worlds stay coherent: institutions, discretion, and the management of risk. By the time these systems matured, offshore structuring, private aviation, insulated real estate, another layer had become just as important: the social and institutional layer that gives private power its stability. Elite wealth does not operate only through money. It operates through interfaces, universities, foundations, museum boards, charitable initiatives, investment conferences, and the quiet professional class that manages high net worth life: attorneys, accountants, private bankers, pilots, property managers, and security contractors. These aren't shadow systems. They are mainstream systems designed to be compatible with privacy and reputation management. In the United States, philanthropy has long offered a particularly effective interface. Donors receive tax advantages, but the deeper advantage is legitimacy. Philanthropy creates reasons for wealthy individuals to appear in public life in controlled ways, at galas, on boards, in university circles, without disclosing the operational details of how they earn or structure their money. Over time, the philanthropic sector also became more financially sophisticated, adopting structures that provide donors autonomy and, in some cases, additional privacy. Scholars and journalists have documented how modern philanthropic vehicles can expand elite control while lowering public accountability compared with older, more regulated norms. At the same time, elite social worlds rely on gatekeepers. Invitations do not come from a single person. They come through chains of trust, recommendations, shared affiliations, and institutional credentials. In practice, this means a reputation can be constructed through proximity. Someone who appears alongside prestigious universities, well-known philanthropies, and prominent public figures can be perceived as vetted, even when the underlying sources of wealth or influence remain opaque. This is not a flaw in one institution. It is a structural effect of how status is transmitted, through association, not audits. Then there is the role of law and compliance, often misunderstood as a barrier to elite discretion, when in reality it can function as its scaffolding. In the offshore domain, for example, the growth of international financial centers prompted formal responses from major institutions by the late 1990s. The OECD's 1998 report on harmful tax competition and subsequent work signaled that governments recognized how preferential regimes could erode tax bases and shift burdens onto less mobile taxpayers. But these responses also reveal a central tension. While policymakers sought to curb abusive practices, the legal infrastructure enabling cross-border entity formation and confidentiality was already deeply embedded in global finance. Regulation tended to narrow extremes, not eliminate the underlying tools. Discretion, in other words, was not an accidental byproduct. It was often a feature offered competitively by jurisdictions and service providers within legal boundaries. The same dynamic appears in the operational world of private travel. Private aviation is regulated, but it is regulated in a way that accommodates speed and controlled access. Customs procedures for general aviation include formal steps, advanced submissions, coordination, and designated arrival points designed to make legal entry efficient, often via private terminals rather than public concourses. The system does not waive oversight, it streamlines it. That difference matters because streamlined oversight can reduce the number of human checkpoints where questions might otherwise be asked, and it allows high-frequency international movement to become routine rather than remarkable. In this environment, privacy becomes operational. It is built into the workflow. Staffing and household operations are another crucial layer. Wealthy households and private enterprises frequently use confidentiality agreements as standard practice, especially for roles involving travel coordination, access to residences, or proximity to clients and guests. NDAs are not evidence of wrongdoing. They are often framed as protections against tabloid culture, theft, harassment, and security threats. But they also create compartmentalization. They ensure that the people who keep a private world running may have limited ability or incentive to describe it as a whole. Compartmentalization is how complex private environments stay stable. A pilot knows flight plans and schedules, but not necessarily the household's internal life. A property manager knows maintenance cycles and staffing rosters, but not financial structures. A lawyer knows entity ownership and contracts, but not day-to-day logistics. Each person handles a narrow slice, often interacting through intermediaries. This is efficient, legally normal, and widely used in elite contexts. It also means that accountability can become diffuse, even before anything goes wrong. And when something does go wrong, elite systems tend to respond first by managing risk. Risk management is not only legal defense. It includes public relations, institutional distancing, negotiated exits, and quiet settlements where legally permissible. It also includes an instinct, shared by many organizations, to minimize reputational exposure until facts force a different posture. The goal is containment. Protect institutions, protect donors, protect boards, protect careers. This is not a conspiracy, it is an incentive structure. Now place that incentive structure beside jurisdictions built to attract wealth through favorable rules. The U.S. Virgin Islands, for example, has long used tax incentive programs to attract businesses and investment, offering dramatic reductions in certain taxes for approved participants. These programs are publicly described as sanctioned through federal law frameworks and promoted as tools for economic development. Such incentives can be legitimate and beneficial for local economies, but they also contribute to a wider ecosystem in which affluent individuals and companies can choose locations not only for beauty or lifestyle, but for administrative advantage, tax treatment, regulatory posture, and distance from mainland scrutiny. By the late 1990s and early 2000s, these elements had fused into a recognizable model of modern elite autonomy. Capital that could be structured through layered entities across jurisdictions, reducing public traceability without necessarily breaking the law. Mobility that could move through regulated but highly streamlined channels, private terminals, pre-arranged customs processing, minimal public visibility. Property that could function as controlled space, urban, rural, and offshore, built not to disappear from maps, but to operate with internal rules. Philanthropy and institutional affiliation that could translate private wealth into public legitimacy, while keeping operational details largely out of view. This is the landscape into which Jeffrey Epstein enters, not as the creator of these systems, but as a user of them. His private world would be assembled from tools that already existed, maintained by professionals trained to protect discretion, and stabilized by institutional environments that often treat reputational risk as a problem to be managed, rather than a warning to be investigated. And once those tools are in place, jets, properties, staffing, legal structures, the question becomes less about any one man's biography and more about how a private world can function as a machine. That machine is best understood by looking at it from multiple angles: power, architecture, logistics, financial obscurity, and the gatekeepers who kept it coherent. Angles, multiple lenses on the same private world. Angle 1. Power and access. Power in elite environments rarely announces itself. It accumulates quietly through access that appears routine and relationships that seem unremarkable on their own. In Jeffrey Epstein's case, public records and contemporaneous reporting show repeated proximity to influential institutions and individuals across finance, politics, academia, and philanthropy. This proximity did not confer authority in a formal sense. Epstein did not hold elected office. He did not run a publicly traded corporation. He did not lead a major foundation with transparent governance. Yet access itself functioned as power. Access determines who is allowed into certain rooms and who is assumed to belong there. Invitations to conferences, private dinners, academic events, and philanthropic gatherings operate on trust by association. When an individual appears repeatedly in elite settings alongside recognized figures or institutions, that presence can substitute for scrutiny. The question becomes not who is this person, but who brought them here. Investigative journalism has shown that Epstein positioned himself as a connector, someone who could introduce wealthy donors to institutions, institutions to donors, and individuals to each other. This role did not require formal credentials. It required social fluency, discretion, and the ability to move comfortably between domains that often remain siloed. Importantly, access is self-reinforcing. Once established, it generates further invitations. It creates assumptions of vetting that no single institution is actually responsible for performing. This diffusion of responsibility is a structural feature of elite social worlds, not an anomaly. In such an environment, exclusion is rare until risk becomes visible. Inclusion, by contrast, is often automatic. That dynamic helps explain how Epstein's private world could overlap with mainstream institutions for years without sustained inquiry. Access did not mean endorsement, presence did not mean approval, but in practice the distinctions blurred, allowing a privately controlled network to operate alongside public life with minimal friction. Angle 2. Wealth and financial obscurity. The scale of Epstein's resources has been widely discussed, but the mechanics of how that wealth was structured matter more than any single estimate. Court filings, tax records introduced in litigation, and investigative reporting indicate that Epstein's financial affairs were managed through a complex web of entities, limited partnerships, trusts, and corporations registered in multiple jurisdictions. These structures are common among high-net-worth individuals. Their primary function is to separate assets, limit liability, and manage tax exposure. What distinguishes such arrangements is not secrecy but opacity. In many cases, beneficial ownership is shielded from public view by design. Disclosure requirements vary by jurisdiction. In some places, corporate registries list only nominee directors or managers. In others, trust arrangements place assets under the control of trustees who act on behalf of beneficiaries whose identities are not publicly disclosed. These mechanisms are legal. They are routinely used by families, investment funds, and multinational corporations. But when layered together, they can make it difficult for outsiders, including journalists and regulators, to form a complete picture of control and cash flow. Financial institutions play a central role in maintaining these structures. Private banks and wealth management firms offer integrated services, investment management, entity formation, tax planning, and coordination with legal counsel. Client confidentiality is a core selling point, reinforced by professional ethics and, in some jurisdictions, statutory protections. In Epstein's case, court proceedings and media investigations have shown that banks processed large volumes of transactions connected to his entities over many years. The existence of those relationships does not imply wrongdoing by financial institutions unless established in court. It does, however, illustrate how elite financial systems prioritize client service and regulatory compliance over holistic assessments of reputational risk until that risk becomes unavoidable. Obscurity in this context is not invisibility, it is fragmentation. Information exists, but it is distributed across institutions that do not share a mandate to assemble it into a single narrative. That fragmentation is what allows private wealth to function at scale without corresponding public accountability. Angle 3. Architecture and controlled spaces. Physical space is one of the most under-examined elements of private power. Epstein's properties, documented through deeds, zoning records, and court exhibits, were not merely residences. They were controlled environments. A Manhattan townhouse with multiple floors and limited sightlines, a large Palm Beach estate set back from the road, a ranch in New Mexico spanning thousands of acres, an island in the U.S. Virgin Islands accessible primarily by private aircraft or boat. Each location had distinct legal and geographic advantages. Urban properties offered proximity to institutions and anonymity within density. Rural and offshore properties offered distance, limited oversight, and jurisdictional complexity. Architecture in these contexts serves function as much as form. Large properties allow activities to be compartmentalized. Staff can be segregated by role. Access can be controlled through gates, security protocols, and scheduling. Visitors can be received without interacting with the surrounding community. Investigative reporting has shown that Epstein employed staff across his properties: house managers, assistants, drivers, maintenance workers, each operating within defined parameters. Employment agreements often included confidentiality provisions. This was standard practice for elite households, not unique to Epstein, but in combination with scale and geographic dispersion, it reduced the likelihood that any one person could observe or report on the full scope of operations. Controlled spaces also benefit from regulatory distance. Local authorities may have limited jurisdiction over offshore properties. Zoning and inspection regimes vary widely. In some locations, large private estates interact minimally with public oversight unless specific complaints are filed. The result is a physical infrastructure that supports autonomy. When legal scrutiny eventually emerged, these same properties became evidence, documented, mapped, and litigated. But for years they functioned as intended, visible on paper, insulated in practice. Together, these angles, access, financial obscurity, and controlled space, do not explain behavior. They explain capacity. They show how a private world could operate continuously, coherently, and legally adjacent to public systems. The remaining angles examine how that world was staffed, protected, and socially stabilized, and how proximity to political and institutional power shaped its resilience. The remaining mechanisms: gatekeepers, proximity, and the operating manual. Angle 4, social hierarchies and gatekeepers. Elite environments rarely run on formal titles alone. They run on filters, assistants, schedulers, private staff, lawyers, and institutional intermediaries who decide what becomes possible and what never reaches the calendar. In the world Epstein built, gatekeeping was not a single person turning a key. It was a layered process. Introductions routed through well-placed acquaintances, meetings arranged through assistants, travel coordinated by pilots and household staff, and invitations shaped by people whose job was to smooth friction. The structure mattered because it allowed relationships to form without any single participant owning responsibility for the whole. This is one of the oldest features of private wealth. The more insulated the environment, the more important the intermediaries become. Gatekeepers screen access, manage schedules, and control the flow of information. They also create distance. If a question arises about a visitor, a trip, an unusual request, the system offers multiple places for accountability to dissolve into routine. Institutions amplify this dynamic. Universities, nonprofits, conferences, and social clubs are designed to welcome donors, connectors, and friends of the organization while maintaining polite boundaries around private life. In practice, that means credibility can be borrowed through association. A person who appears at the right tables with the right introductions can be treated as vetted, even when nobody has actually done the vetting. That distinction becomes critical later when names appear in documents. Photographs released by congressional investigators decades after the fact show Epstein with prominent political figures and public personalities. Those images document contact, not criminal conduct. The presence of a person in a photo does not establish involvement in wrongdoing, and it does not prove knowledge of what was happening inside Epstein's private world. but the images do help explain how his access could feel normal in elite circuits. Proximity itself can be a credential. This is how a private world stays coherent, not through secrecy but through social permission, granted one invitation at a time. Angle 5. Political and institutional proximity. Some of the most consequential evidence in this story isn't a confession or a hidden tape. It's paperwork that shows how ordinary elite life intersects with private infrastructure. Flight logs, schedules, correspondence, and photos. Flight logs released as evidence in United States versus Ghislaine Maxwell, entered as a government exhibit, provide a dated record of aircraft movements and, in many instances, listed passengers. These logs have been published publicly and have become a central source for reconstructing Epstein's travel patterns and the operational regularity of his private aviation network. A name appearing in such a record is not proof of wrongdoing. It can mean any number of things: a social connection, a professional trip, a brief presence, or a clerical inclusion. The logs document movement, not intent, but they demonstrate something else that is structurally important. Epstein's aircraft functioned as a mobile extension of his private world, capable of moving across borders repeatedly with the legitimacy and convenience that private aviation provides. The same is true of newly released photographic and documentary materials. In late 2025 and early 2026, major outlets reported on additional images and files released through congressional channels and broader government disclosures, renewing attention on Epstein's documented contacts across public life. These releases again underline the same mechanism. Proximity to institutions and public figures can coexist with a lack of scrutiny, especially when interactions appear socially conventional at the time. In some instances, post-2008 contact has been the subject of fresh reporting based on newly surfaced government materials, emphasizing how reputational breaks often lag behind private realities. Where such reporting concerns individuals not charged with crimes, it must be read narrowly as evidence of communication or association, not criminal implication. This proximity, documented, explainable in ordinary social terms, and rarely interrogated in real time, helped keep the private world intact until law enforcement pressure made distance suddenly necessary. Angle 6. Logistics, staffing, NDAs, and security. If access is the currency of elite life, logistics is the machinery that spends it. A private world of this scale does not run on spontaneity. It runs on staffing rosters, travel schedules, property maintenance, procurement, and confidentiality. The most revealing question is often not who visited, but what did it take to make visiting effortless? In high-net-worth households, non-disclosure agreements are commonplace. They protect privacy, limit exposure to tabloids, and reduce security risks. In the Epstein case, public reporting and document releases indicate that NDAs existed among the materials associated with his estate and operations, one piece of a broader system of controlled information. The existence of an NDA does not establish wrongdoing. It establishes that secrecy and reputation management were operational priorities. Staffing itself can be a form of compartmentalization. Large properties and frequent travel require many hands, but those hands can be organized so that no single person sees the whole. One team handles schedules, another manages maintenance. Pilots receive flight plans. Household staff follow instructions. Security manages perimeters. Each role can be professional, legal, and routine. Yet the cumulative effect is an environment where oversight is externalized and visibility is limited by design. This is why infrastructure matters more than personality. The system does not require crowds. It requires reliability, a small circle of trusted employees, consistent travel pathways, and controlled spaces where outside observation is minimal. And when allegations begin to surface, the same logistics become defensive architecture. Travel can be reduced or rerouted. Staff can be rotated. Advisors can negotiate. Institutions can distance themselves. The machine does not stop. It adapts. These angles together describe a world that was not mythical or hidden underground. It was a functioning, documented network, built from ordinary tools of modern elite life. And then, inevitably, a network built to minimize friction encounters the one force it cannot fully streamline: the criminal justice system. Climax: when the machine meets the record for years, Epstein's private world functioned the way insulated systems are designed to function: quietly, predictably, and with few points of contact where outside authority could slow it down. Then, in Palm Beach, Florida, the system encountered something it could not fully manage: an investigation that began at the local level, in a jurisdiction small enough that patterns could become visible. By 2005 to 2006, Palm Beach police had begun investigating allegations involving underage girls and Epstein's Palm Beach residence. The early phase of the case moved through ordinary channels: interviews, statements, and the slow assembly of corroboration. The details of those investigative steps live across court filings and later reporting, but what matters structurally is this: the case did not begin as a national scandal. It began as a local inquiry that challenged the assumption of insulation. As the investigation escalated, it did what many such cases eventually do. It moved into the orbit of federal decision-making, where discretion becomes a policy tool. A federal investigation ran alongside the state process in 2006 to 2008, handled by the U.S. Attorney's Office for the Southern District of Florida. Years later, the Department of Justice Office of Professional Responsibility would review how that federal investigation was resolved, describing a process that culminated in a highly unusual outcome: a federal agreement not to prosecute Epstein in exchange for a state plea arrangement and other conditions. The agreement itself is not a rumor. It exists as a document, a non-prosecution agreement that states that federal prosecution shall be deferred in favor of prosecution by the state of Florida, subject to conditions. The mechanism mattered more than the language. In practice, the agreement meant that the most powerful prosecutorial tool, federal charges, would not be used at that moment, and the case would be contained within a narrower state resolution. The DOJ's later review made clear that the handling of victims during this process became part of the controversy because victim notification obligations and interactions were central to subsequent scrutiny and litigation. This is the first visible fracture in the private world, not a dramatic collapse, but a controlled settlement of risk. In 2008, Epstein entered a state plea in Florida, an outcome that, whatever its legal particulars, had a practical effect. It limited exposure at the federal level and imposed penalties that did not dismantle the underlying infrastructure of his private world. The system absorbed the impact. Properties remained. Assets remained. Mobility remained. The private network of staffing and logistics did not evaporate. It continued operating. This is one of the defining features of elite insulation. A legal outcome can close a case without closing the environment that made the conduct possible. The next phase unfolded more slowly, and at first it looked like the story might remain contained in the way so many high-profile cases do, bounded by jurisdiction, reduced to a set of charges concluded in a courtroom. But containment depends on silence, and silence depends on stability. Over the next decade, civil litigation and public interest continued to circle the edges of the story. The private world did not disappear. It remained operational enough to sustain continuing questions, continuing scrutiny, and continuing pressure from survivors and advocates, pressure that did not rely on spectacle but on the persistence of documentation. Then, in the late 2000s, the structure began to fail in a different way, not because the private world changed, but because the public record expanded. By July 2019, the federal system returned. A grand jury in the Southern District of New York issued a sealed indictment dated July 2, 2019, charging 1 count of sex trafficking conspiracy and 1 count of sex trafficking. The charges were unsealed shortly afterward. The U.S. Attorney's Office for SDNY publicly described the unsealed case on July 8, 2019, stating that Epstein was charged with sex trafficking of minors and conspiring to commit sex trafficking of minors, with alleged conduct in New York, and Palm Beach, Florida, among other locations. The dates matter because they show speed, how quickly a world built. Uncontrolled movement can suddenly be pinned to a calendar. The indictment described a pattern: recruitment and enticement of minor girls, abuse occurring at residences, and cash payments, framed not as isolated incidents, but as a system with repeated methods across time and place. On July 8, 2019, Epstein was arrested. For the first time, the private world was not merely criticized or questioned, it was formally charged at the federal level, in a jurisdiction that could reach beyond a single county and beyond a single negotiated resolution. And now the mechanics that had once supported discretion became evidence. Residences were no longer simply properties. They were alleged sites tied to specific conduct. Aircraft were no longer simply transportation. They were part of a mobility pattern that could be reconstructed. Schedules and contacts were no longer just social history. They became relevant context, requiring careful interpretation without turning association into accusation. This is a critical boundary in responsible narration. Many names appear in flight logs, address books, photos, and social calendars connected to Epstein. A name appearing in a record can indicate contact or travel, but it does not prove knowledge of wrongdoing, participation, or criminal conduct. In the federal case against Epstein, the charges were against Epstein. The indictment is a legal document describing alleged conduct by the defendant, not a sweeping verdict on everyone who crossed his path. Still, once federal charges were filed, the private world entered a different atmosphere, one governed by court procedures, detention protocols, discovery obligations, and scrutiny that could not be negotiated away in private. Inside MCC New York, Epstein was placed in federal custody as he awaited trial. On August 10, 2019, he died in custody. The Department of Justice Inspector General later reported that he died by suicide while detained at the Metropolitan Correctional Center in New York. The death did not end the story. It changed its shape. A prosecution that would have tested the architecture of the private world in open court stopped abruptly. The case against the person ended, but the questions about the system, the institutions that enabled discretion, the earlier agreements that constrained accountability, the mechanisms that protected the world's continuity, remained active, now redirected into investigations, reports, civil litigation, and public institutional reckoning. The private world had been designed to survive interruptions, but this interruption was of a different kind. It removed the central figure while leaving the structure behind. Assets, entities, records, and reputations still embedded in public systems. And that is where the second part of the climax begins. Not with the charges themselves, but with what happened after the world lost its center. How institutions responded, what processes activated, and what forms of accountability were still possible once a criminal trial could no longer take place. What a collapsed center leaves behind. When Jeffrey Epstein died on August 10, 2019 in federal custody, The criminal case against him stopped in the strictest legal sense, but the machinery around it accelerated. A private world built to control information now generated documentation at scale. Detention logs, investigative reports, court filings, civil complaints, corporate disclosures, and institutional statements. The system did not reveal itself in a single moment. It was pulled apart by process, each institution producing records for its own reasons, each record adding structure to what had previously been managed as discretion. The first response was administrative and immediate. Custody became a subject of investigation. The U.S. Department of Justice Office of the Inspector General later issued a report examining the Bureau of Prisons' custody, care, and supervision of Epstein at the Metropolitan Correctional Center, MCC, in New York, stating he died by suicide and describing multiple failures in staffing, supervision, and adherence to policies. This report mattered for a specific reason. It treated the final days not as legend or rumor, but as a regulated workflow that had broken down. It described a chain of ordinary institutional vulnerabilities, short staffing, missed rounds, flawed protocols, that, in this case, became globally visible. The private world had relied on controlled environments. In custody, Epstein was inside the state's controlled environment, and that environment proved fallible. At the same time, a second reality took shape. The center of the story was gone, but the legal system still had tools to pursue. Federal investigations did not dissolve. Civil litigation did not pause. Survivors' claims continued, and the question shifted from a single defendant to a network of entities, decisions, and accountability mechanisms that were already in motion. The most direct continuation in criminal court came through the prosecution of Ghislaine Maxwell. Maxwell was arrested in July 2020 and charged in the Southern District of New York. Prosecutors described the case as focused on conduct spanning years, alleging that she helped recruit and groom minors for Epstein's abuse. In December 2021, a jury convicted Maxwell on multiple counts. She was sentenced in June 2022 to 20 years in prison, according to the SDNY case updates and court reporting. The Maxwell case is essential to the structural story, not because it explains Epstein's world in full, but because it forced parts of that world into open court. Testimony about recruitment patterns, travel, and the way access was managed. Court is not a documentary lens. It is a procedural machine with its own constraints. Evidence rules, witness credibility standards, and narrow legal definitions. But precisely because of those constraints, it produced a public record that did not depend on whispers. In September 2024, a federal appeals court upheld Maxwell's conviction. This matters because the system's second fracture was not emotional, it was procedural. The world began to break not simply because it was exposed, but because it became adjudicated piece by piece inside institutions that generate permanent records. Meanwhile, civil actions and settlements began to redraw the map of the private world's assets. In June 2020, the Epstein estate established the Epstein Victims Compensation Program, which paid out roughly $121 million to more than 135 survivors before it closed in August 2021, as reported by multiple outlets. This, too, is a structural event. It did not require a criminal conviction. It did not require a trial. It was a mechanism for distributing money through a defined process, with defined requirements within the realities of estate administration and ongoing litigation. It signaled that the estate, an institutional entity, was being reorganized around claims that could no longer be treated as marginal. At the territorial level, the U.S. Virgin Islands pursued a separate legal track. The territory filed a civil enforcement action in 2020 and later announced a settlement with Epstein's estate for over $105 million, including cash and a share of proceeds tied to the eventual sale of Little St. James, the island. The settlement language and official statements framed it as a resolution of claims in that government lawsuit. It did not function as a criminal conviction, and such settlements often include carefully limited admissions or none at all. What it did do was convert the island from a symbol of insulation into a liquidating asset, something that had to be handled through courts, valuations, and sales processes rather than private schedules. At the corporate level, the private world's financial interfaces also became visible through litigation. Major banks faced lawsuits alleging failures in how Epstein's accounts and transactions were handled. Some of these cases ended in settlements. For example, the Associated Press reported a $290 million settlement in a class action with victims and a separate $75 million settlement with the U.S. Virgin Islands involving J.P. Morgan Chase, both connected to claims about the bank's relationship with Epstein. In a documentary grounded in verifiable records, the careful line is this: a settlement is not a criminal verdict. It typically reflects a negotiated resolution of civil claims without a full trial determination. But it is evidence of institutional consequence, money paid, policies reviewed, reputations recalculated because litigation forced the relationship into discovery and public scrutiny. And this is where the private world's defining feature, controlled visibility, fully collapses. When a system relies on discretion, it can withstand gossip. It can withstand isolated reporting. What it struggles to survive is compulsory process, subpoenas, sworn testimony, discovery obligations, and judicial orders. These do not simply expose a world. They convert it into paper. That conversion has an aftershock. Names begin to appear everywhere: flight logs, address books, photographs, calendars, and correspondence. Those records often document contact, proximity, or travel. They do not, by themselves, prove criminal conduct or knowledge. In responsible narration, the rule is simple. Association is not accusation. A name appearing in a document can indicate many kinds of connection, including innocent or limited contact, and it must never be presented as proof of involvement unless charged conduct is established in court. Still, the flood of records changes the atmosphere. Institutions that once treated association as normal begin to treat it as risk. Public figures issue statements. Boards evaluate reputational exposure. Universities and nonprofits revisit donor relationships. The same gatekeeping system that once smoothed access begins to enforce distance. And in the background, the estates, aircraft, properties, and entities continue to exist, still requiring management, still sitting in registries and court dockets, still generating decisions that someone has to sign. That is the third fracture. The private world becomes administrative, not glamorous, not cinematic, just the reality of dismantling: trustees, court supervision, claims processes, and asset disposition. By the time the legal system had shifted from one defendant to a broader set of proceedings, criminal prosecution of a close associate, compensation programs, territorial enforcement actions, and corporate litigation, the private world no longer operated as a sealed environment. It had become a portfolio of contested assets and contested reputations, processed through institutions designed to absorb shock and continue functioning. And that brings the story into its next phase. What happened to the physical places, the financial entities, and the people around them once the center was gone and the systems had to decide what closure would actually mean? Assets, estates, and the slow work of dismantling after August 2019, the first visible question was not symbolic. It was practical. What happens to a private world when the person at its center is gone? In law, the answer begins with a simple mechanism: probate and estate administration. But in practice, it becomes an extended negotiation between courts, claimants, governments, and the professionals who keep complex assets from collapsing into chaos. Jeffrey Epstein's assets did not dissolve with his death. They remained held through an estate, layered entities, and property titles that had been established years earlier. Homes still required security. Aircraft still required storage, maintenance, insurance, and eventual disposition. Companies still existed on paper, even if their purpose had ended. Staff contracts, vendor agreements, and ongoing costs continued to accrue. A world built on logistics does not disappear. It must be unwound. One of the most consequential steps was the creation of a formal channel for survivor compensation. The Epstein Victims Compensation Program, established in 2020 and administered independently, announced that it ultimately paid about $121 million to more than 135 survivors before closing in August 2021, according to contemporaneous reporting. This program is significant because it demonstrates how, after a criminal case ends, systems shift toward administrative resolution. Claims forms, documentation standards, eligibility decisions, and disbursement schedules. It is not a courtroom drama, it is institutional processing, but it is also one of the few ways money held in an estate can be routed toward accountability when a trial is no longer possible. At the same time, governments moved to address what their own systems had enabled or failed to prevent. The U.S. Virgin Islands, where Epstein owned Little St. James, pursued civil enforcement and later announced a settlement with Epstein's estate of over $105 million, including cash and a share of proceeds tied to the island's eventual sale. Again, the structural meaning is not hidden in a headline. It is in what the settlement forces: valuation, liquidation, and formal transfer. A private island is not only a place, it is a legal object. Deeds, permits, zoning constraints, liens, contracts, and marketability. Once it becomes central to litigation and settlement, it moves from being an insulated environment to being an asset that must survive court oversight. And then there are the properties. Epstein's residences, documented through property records and widely reported, were spread across multiple jurisdictions: New York, Florida, New Mexico, the U.S., Virgin Islands, and overseas. Each location imposed different rules, different real estate markets, different creditor priorities, different legal processes. The estate had to navigate these differences while responding to mounting claims and public scrutiny. Disposal of high-profile assets is rarely simple. Buyers are cautious, insurers are cautious, local communities react. The market price becomes entangled with reputational risk and invisible cost added to square footage and land value. Even if a property is structurally ordinary, its history becomes part of its valuation. The aircraft followed a similar logic. Private jets are not just possessions. They are regulated objects with maintenance logs, certifications, and storage requirements. Any eventual sale requires compliance steps that cannot be bypassed. This is where the story of private aviation becomes purely procedural. Once the system turns against you, a jet is no longer freedom. It is a depreciating asset sitting inside a compliance framework. Meanwhile, the entities that once held assets, corporations and trusts, did what such structures are designed to do. They continued to exist until dissolved or repurposed. They did not confess. They did not collapse. They simply remained on paper until the estate and courts decided what to do with them. This is one of the central realities of modern elite infrastructure. It persists beyond the individual. It is meant to. But the aftermath did not unfold only through real estate and liquidation. It unfolded through reputations, through institutions forced to answer why proximity had been treated as normal, and why warning signs had not triggered earlier action. Because once a private world is dismantled, the next question is unavoidable. What happens to the people and institutions around it? Associates, banks, universities, philanthropies, and public figures whose names appear in records not as proof of guilt, but as evidence of how embedded the world had become. Reputations, distance, and what did not change. As the estate was processed and assets were dismantled, attention shifted outward to the institutions and individuals whose proximity to Epstein had once been unremarkable and later became something to explain. Universities reviewed donor relationships, boards reassessed affiliations, financial institutions announced policy changes and compliance reviews. Public figures issued statements clarifying the nature and limits of past contact. In each case, the pattern was similar: separation without retroactive judgment, distance without collective reckoning. This response was shaped by law as much as by caution. Many people whose names appeared in flight logs, address books, or photographs were never charged with crimes. Their inclusion in records documents contact, not conduct. Institutions aware of legal exposure and ethical boundaries largely confined themselves to forward-looking reforms rather than retrospective accountability. Some consequences were tangible. Banks paid settlements, governments extracted monetary resolutions, compliance frameworks were updated, internal reviews were commissioned. These actions mattered, but they did not fundamentally alter the systems that had enabled discretion in the first place. Private aviation did not become more transparent. Offshore finance did not disappear. Elite philanthropy did not surrender autonomy. The tools remained. Only one user was removed. What changed most clearly was tone. Where access had once been casual, it became cautious. Where proximity had once been neutral, it became reputational risk. The same gatekeeping structures that had once smoothed Epstein's path now worked to ensure his absence. And slowly, the story began to settle, not into closure but into institutional memory. Court records archived, settlements finalized, properties sold. The private world dissolved into documents, its physical form broken apart, its infrastructure absorbed back into ordinary systems. Yet the underlying architecture, the ability to build a private world inside public systems, remained intact. That is the final tension of this story. Not that one world existed, but that it could exist again, using the same legal tools, the same financial mechanisms, and the same structures of access, unless transparency becomes more valuable than discretion. A world that fit the system. The most instructive thing about Jeffrey Epstein's private world is not how unusual it was, but how well it fit. It did not require secret laws or hidden permissions. It relied on ordinary tools. Legal entities designed to protect assets, aviation systems designed to move people efficiently, properties acquired through transparent markets, and institutions accustomed to treating wealth as a credential. Each component functioned as intended. Together, they produced an environment where scale could exist without visibility. This is the quiet lesson of the record. Modern power does not always concentrate in governments or corporations. It accumulates in the spaces between them, where regulation is fragmented, responsibility is distributed, and legitimacy is borrowed through association. In those spaces, accountability tends to arrive late, if it arrives at all, and only after harm has already occurred. The dismantling of Epstein's world did not come from a single moral awakening. It came from process. Police reports, court filings, investigative journalism, civil claims, settlements, and administrative review. None of these were dramatic on their own. Together, they formed a slow pressure that eventually overcame insulation. Even then, the systems adapted. Assets were liquidated, claims were processed, institutions recalibrated, the structure absorbed the shock, and continued operating largely unchanged. That continuity is not evidence of failure or success. It is evidence of design. Private worlds can exist inside public systems because those systems reward efficiency, discretion, and delegation. They assume good faith, they rely on fragmentation, and they rarely ask how much autonomy is too much until the cost becomes visible. This story ends quietly, not because it lacks weight, but because its implications extend beyond one man, one case, or one set of headlines. It is a case study in how power moves when it does not need to announce itself, and how difficult it is to dismantle once it has been normalized. Nothing about this world was invisible. It was simply permitted to operate without being fully seen. And that, more than any individual act, is what endures.